Hi there, this is Jonathan Ginsberg, and today I'd like to talk to you about a technique you can do. Your attorney will really need to do it for you, but that involves reopening an old application. Frequently when I meet with clients, I discover they had previously filed an application for disability benefits, but for whatever reason they got the denial notice and they did not appeal. Sometimes they got a denial notice and did appeal, and they filed for reconsideration. That was denied. They did not appeal that to a hearing. So there's a prior application, series of applications or whatever, and now they have a current application, and they're going to a hearing and they want to know, is there anything I can do about those prior applications? And the answer is actually yes. You can reopen an old application, but there are some steps and there are some rules that apply to this, and that's what I want to talk to you about today. First of all, to reopen an application for benefits, again, that means going back and using the original application, a prior application, and going back in time to try to get past due benefits, going back several months or years, which obviously can mean several thousands of dollars in your pocket. You have to ask for it. Judges are not going to do it automatically, so it's important that if you think there was a prior application, you know there was a prior application, you want to make sure that you or your attorney specifically requests a reopening with the judge who's hearing your case. If you don't ask for it, judges will not do it automatically. So it is something that is, you're going to have to ask for it. Secondly, the way the rules work is if you previously applied and were turned down, your new application must be filed within 1 year from the date of the initial denial of the previous application. So here's an example. Let's say that you applied for benefits January 15th, 2008. It was denied April 17th of 2008. You reapply in February of 2009. You're okay in terms of being able to reopen because your new application was filed about 9 months after the prior denial. However, if you refile your new application or file a new application in July of 2009, it has been more than a year since your initial denial. In that case, you cannot reopen the new application absent special circumstances. And when I say reopen as of right, you can reopen basically for any reason within 1 year. And there's some rules that go out. We'll talk about the rules about beyond 1 year, but generally you want to be looking to reapply within 1 year. And note that it's from the date of the denial of the initial application. So if you filed an application, you were denied, again, April 17th of 2008, you filed for reconsideration. The reconsideration denial was in July of 2008, and you reapplied in July of, say, June 30th of 2009, that doesn't work. It's got to be within 1 year of the denial of the initial application, not the denial of any reconsideration or anything else. So it's really important if you're denied and you don't appeal and it's too late, you missed the 60-day appeal time, it's really important to reapply within 1 year to preserve the right to reopen your initial application, your first application, and go back in time to that initial filing date. And this is actually important for a lot of reasons. Obviously, one is it could put more money in your pocket, but two, if the date last insured for Title II disability has run and you need to go back in time, and you can do that by reopening, but there are some situations where if your date last insured has run and you reapply, the earliest onset date the judge will give you is the day after the initial denial from the prior application. So if your onset or if your date last insured has already run and you reapply, you may win and get an approval, but if the date that you're approved on is after your insured credits have run out, doesn't do you a whole lot of good. So it's really important for you and your attorney to be aware of the date last insured for Title II disability, the date of your initial application, the first time you applied, the date of the current application, and of course the date of the denial of the prior application. I realize this is kind of technical. The most important thing for you as a claimant to know is that you can reopen an old application, and to make sure that you talk to your attorney about doing so if there was a prior application, and to make your attorney aware of your prior application. Sometimes people don't tell you, my clients sometimes don't tell me, and the first time I notice it is when I'm looking at the exhibit file. I see there was reference to a prior application, and then I find out that I can reopen, and my client ends up with $10,000 more in his pocket, which makes him real happy. So be aware of that. Now, I mentioned that you can reopen within 1 year of the prior application's denial as of right, and you can pretty much, well, I shouldn't say as of right, but for any reason at all. And you can show really any reason you didn't know that you were supposed to file the appeal. There's some new evidence. It could be that your mental state was such that you didn't know what to do, and so forth. Really, pretty much any reason. If you miss the 1 year reopening time, the rules in Social Security say you can reopen within 4 years in an SSDI application, but you've got to have good cause, and the good cause needs to be pretty good. Judges are really, really reluctant to do this, but if you can show that you didn't speak English, that your mental state was such that you just had no capacity to understand what to do, how to hire an attorney, that you were out of the country for some reason, that there was just some extenuating circumstance, that you can show that there was no delivery of the denial notice to you at all, and you can prove that, but you've got to have a really, really pretty compelling reason. So I wouldn't count on that, but again, if you have a date last insured problem and you have no credits and you have nothing to lose, then ask for reopening. But you need to, I would probably tell you that your attorney needs to submit a brief with that and show something really, really compelling, because otherwise judges are really reluctant to do it. So big picture here is, if you filed a previous application, there are situations where you can and should try to reopen that old application. Certainly it'll put more money in your pocket, but it could also save your claim in terms of your date last insured. Make sure that you tell your attorney that you had a previous application, and make sure that the attorney knows that he needs to ask the judge to reopen. It will not happen automatically. So that's what you need to know, kind of very briefly, about reopening prior applications. Hope this has been helpful. Again, this is Jonathan Ginsberg, and we'll talk to you soon.